Hello and welcome back to our video updates. It's Sade. Today's video is going to cover what options you have if you want to dispute sale of real estate that you believe you have partial interest in. So when the sale has already happened, it's usually in the scenario where family members would cut out a specific family member that they don't believe is supposed to be an owner or part owner of that property. And so we recently got some questions about this type of deal. And most of the time, the title companies are pretty good at catching issues that could potentially come up as far as potential claimants that might come up in the future, saying that they are supposed to be one of the parties to the transaction, or that they were supposed to be one of the parties to the transaction. And so if the title company does not notice or feels comfortable to move forward and ensure title, it means that they are comfortable to defend against any issues that will come up in the future, right? So people sometimes will get away with entering into transactions where they strongly believe that they have the right to sell the property, and then in the future a family member is going to show up and contest that deal. And so what are the options that people have in that scenario? Most of the time we get the calls from the people that were left out, and the options really would be to try to reverse the sale, but it's difficult to reverse a sale like that because of the laws that protect innocent third-party buyers. And in this case, the party that's purchasing the property is considered to be innocent because they're not required to know everything. They don't know whether they were dealing with the right seller, because when people list property for sale, it's presumed that you have the authority and the power to sell that property. And so the buyer is not required to go through any lengths or any more than necessary due diligence to be able to figure out who really owns the property. And that's why it's good for buyers to get title insurance policies, because the title company is supposed to do the chain of title search and look into any issues that might be a problem in future, and make sure that those things are fixed before the closing date. And so usually when the closing has happened, the buyer is somewhat protected under Texas laws anyway as the innocent third-party buyer. And then that complicates things, because in order to reverse the transaction, you're essentially asking the buyer to give back the property that they just paid for and get their money back, of course, and walk away. So typically the money has already exchanged hands as well, and maybe the person that sold the property, or the persons that sold the property, they're already enjoying the funds that they collected at closing, and they might already have spent most of it by the time that you find out that the property sold and that you're now contesting the sale. So what are your options as the person that was left out? Your option really is to send out demand letters. Obviously, you want to send out a demand letter quickly to all the parties involved, to the parties themselves, to their lawyers and representatives, such as the real estate professionals, and also to the title company. And of course, these types of demand letters have to be really well written to begin with for them to be paid attention to. So I would suggest that you consult with a real estate lawyer to help you to write this type of demand letter. It's not something that you could just do DIY on, in my opinion, because if you DIY, they're just going to ignore it most of the time. And so the next step then is, if the demand letter doesn't work, or if let's say the demand letter is responded to and everybody says, well, we didn't do anything wrong. Let's say everybody responded and said, we didn't do anything wrong, so we're not going to reverse this sale. We're not going to give you any money from the sale or anything like that. And then you then go back to your lawyer, the real estate lawyer. Hopefully your lawyer is also a litigator, which means that your lawyer is comfortable in court. So you would go back to your lawyer and say, what next, right? So I would then suggest, when I'm the one on the case, I would suggest that we file a lawsuit, and the lawsuit is going to be a lawsuit complaining about what was done incorrectly, against your interests. So we'll file a lawsuit in court regarding that piece of property, and I would immediately ask for what we call an injunction, which is just something to stop people from doing something else. So it will be more of a restraining order type that would restrain them or stop them from doing anything at all with the money that they received from the closing. And it will also stop the buyer from doing any kind of development or renovations to the property or doing anything at all. It essentially freezes everybody in place until the court is able to make a decision as to who's right and who's wrong. And of course, we ask for your attorney's fees and court costs and any other types of damages that come up in the meanwhile. So we'll go ahead and file a lawsuit, because a lot of people don't pay attention to letters, but they do pay attention to a lawsuit. So then you'll get their attention, and most times you're able to go to mediation, and mediation would resolve maybe 80% of the issues. Maybe it'll resolve the whole thing, you know. And most of the time mediation does work when people are reasonable. If the mediation doesn't work, which is an informal settlement conference is what it is, with a facilitator helping everybody out to try to listen to all the sides and make people come to the table and negotiate a settlement. So that's the whole point of mediation. Sometimes mediation won't work, and then you end up having to go in front of the court, either a judge or jury, whichever one you like, and then you'll argue your case, and then they'll argue their case. And hopefully the law is on your side and the facts are on your side, and that they actually did things incorrectly. And then in that case, of course, the title company would cover the damages most of the time, because they messed up, because they didn't catch it on time to be able to alert everybody to the fact that they didn't have all the parties that were supposed to be sellers to be able to sell that property. So most of the time you don't necessarily get the property back, but you will be able to get monetary damages. You won't be able to get the property back because of the third-party purchaser, unless the third-party person agrees to back out and move on to something else, get all their money back, maybe plus some damages, of course. So it's very complex because there's so many parties involved. In this case, you know, the seller that was supposed to involve you, so that's one party. You, the person that's complaining of the issues, that's the second party. And then the purchaser is going to be a third party to the case. And then you have the title company, you're going to name them in the case as well, so that's the fourth party. And then of course you can name the realtors if you feel like they should have known, or that they knew about you and just kind of hid that fact. And of course you can then name any other professionals. You can name any other professionals that you think have done wrong. So typically there are 5 to 6 parties involved, and that just tends to make everything a lot more complicated for everyone. So you would then be able to figure out what were the rights and obligations, what were the shares supposed to look like, what other persons were left out, if any, and who was supposed to sign, and whether you want to agree with the sale at all. But typically you don't have any choice when it's already happened. So those are the things that typically take place. My suggestion is, if you think that you own property out there along with other heirs, such as property that you inherited from a grandparent or a great-great-grandparent, just keep an eye out on it and try to see if you could resolve the inheritance issues ahead of time. So it's worth it sometimes to come up with the money, or have all the heirs come to an agreement and sort the title issues out, so that your name is out there on the list of people that own the property or have an interest in the property. And that's usually in form of a deed that was transferred the property to the heirs. If there's no deed in place and the inheritance issues have not yet been sorted out, and you just hear that maybe some cousins are plotting to sell this property without you, and you feel like you have a share in the property, you know, an interest, you truly believe that, then definitely consult with a real estate lawyer. And if you have 2 or 3 opinions saying that they believe that you are an heir, and the cousins are still trying to leave you out, then possibly you could file an affidavit of interest into the property records in that county, so that all third-party buyers would see that affidavit, and that would scare them off a little bit, or at least the title company would see that, and they'll have no reason to move forward with the sale without first resolving the issue with you. So those are our suggestions for that particular scenario, or those kinds of scenarios, and hopefully this has been a little bit helpful to you. If you have people that are going through that, just advise them to not try to DIY. If you have specific questions for your particular situation, as always, make sure to talk to a lawyer in your state that's familiar with real estate laws. And of course, these videos are for educational purposes only, just to give you a general overview of what's possible and what's available. So you have to do your due diligence always, and also consult with the right professionals. And I will be talking to you next time. Be on the lookout for future videos. If you like the channel, make sure to subscribe, and we'll be doing more videos shortly.